Hello, listeners. This is the Musoke with the Democratization of Africa, the case of Uganda in comparative perspective. Today, I'm appearing at a different time because my friend Charlie Bacon and James Makula are unable to present their focus on Uganda. And so, today will be a special conversation. We will try to answer the question whether the 1995 Constitution was a paradox, was a contradiction, or was pure political fraud. So, because of this, the topic I'm going to deal with, I thought that it might be fascinating for some for me to play a different role, that one of a prosecutor. I've never loved to be a prosecutor, but in this case, the person being prosecuted is Yoweri Museveni, Benjamin Odoki, the Attorney General, and others. And the purpose for this is, I've already answered the question whether the 1995 Constitution was just a paradox, a simple contradiction, or political fraud. I've come to the conclusion that there is sufficient evidence that it was political fraud. And so, as we listen to this conversation, bear in mind, you as my listeners, you are going to be the jury. And I'm going to present to you 3 counts against Museveni, against Odoki, the Attorney General, and the others at large. In count 1, we allege that between 1981 and 1995, Museveni, with a design to mislead Ugandans, formulated a fraudulent social theory known as sectarian social theory, which was intended to mislead the people of Uganda by making them believe that there is a causal connection between class configuration and the political behavior of Ugandans. Count 2 alleges that between 1988 and 1995, Yoweri Museveni conspired with others at large to enact a constitution designed to deny Ugandans their inalienable human rights, that is, the right to assemble, the right to associate, and the right to express themselves. And count 3 alleges that between 1994 and 2013, Yoweri Museveni, with others at large, conspired to deny the citizens of Uganda their human rights protected under international law, specifically the rights guaranteed by the Universal Declaration of Human Rights in Article 21 and the International Covenant on Civil and Political Rights, Article 25. So as I proceed, you, my listeners, as the jury, you will determine whether or not the charges are proved beyond a reasonable doubt. And if they are, you have to convict the accused. The makers of the 1995 Constitution described themselves as constitutional innovators because, allegedly, they invented the movement system of government, which they argued was unique in African constitutional history. In response to the claim of the makers of the 1995 Constitution, this conversation explores the nature, the origin, and the political impact and immediate consequences of the movement system on the process of democratization of Uganda. Political system innovation, if the making of the 1995 Constitution was or led to disastrous consequences for democracy. In this conversation, we interpret Articles 20, 29, and 269 of the Constitution in order to determine as precisely as we can the natural meaning of these articles read together. Could these articles be logically applied in normal construction of the Constitution in order to advance the democratization process the Constitution was supposed to promote? Put in another way, what was the impact of Article 269 on the right of the people to enjoy their political freedom? That is, the rights of the people to assemble, to associate, and to express themselves freely as guaranteed by the Bill of Rights contained in the same Constitution, especially in Articles 20 and 29. Construing Article 20, 29, and 269 by giving them their natural meaning, we examine the premises of the sectarian social theory on which the movement system of government was justified and rationalized. The sectarian social theory helps us to understand the hidden political motives from which the charges are outlined and derived, by which the role of the makers of 1995 Constitution played. The only question is whether the sectarian social theory was both scientific and valid. We shall provide a definitive answer to this question. The second part of this conversation looks at the role of the judicial review of the electoral process. And the third, we'll discuss the principles of the supremacy of the Constitution. It's unlikely that we'll go that far today, but that's what we expect to accomplish in the future conversations. Now, going back to the text of the 1995 Constitution.
You are listening to Voice of Uganda Radio, the mouthpiece of all Ugandans, wherever they may be, to voice their problems without fear of any retribution. The Voice of Uganda Radio works in sync with FADU, the Federalist Alliance of Democracy and Development in Uganda. FADU is an organization.
Hello, listeners. I welcome you back to this conversation on democratization of Africa, the case of Uganda in a comparative perspective. We had a little snag at the beginning of the conversation, so we had to straighten out some of the machines that broadcast us on the air, so that we can come out clear and you can hear us in a much better way. But to continue where I was, I said that this particular conversation, I will be performing the role of a prosecutor, prosecuting Museveni, Benjamin Odochi, the Attorney General, and others at large. There are 3 counts which arise from our discussion today. Articles 20, 29, and 269 are very important in the history of Uganda. Article 20 states that human rights are inherent and not granted by the state. And that statement in Article 20 is not a simple legal rule stating what the courts must do about human rights, nor is it a definition of a specific right or rights that the courts must enforce. Article 20 is a general philosophical statement about human rights in general. If this is true, how come we concluded that NRM has no political philosophy to enforce inalienable human rights? The answer is simple. NRM has no political philosophy that is rational and consistent. Article 6 of NRM Constitution makes that very, very clear. Therefore, Article 20 was not enacted in the Constitution because NRM members believed in the content of Article 20. That is why in the previous conversations we made sure and we outlined the political philosophy of NRM in the 10-point program, and especially the CA debate, where the views of NRM members were explicitly articulated. The philosophy on which Article 20 stands was external to the philosophy and ideology of NRM. Article 20 of the Constitution is therefore the result of the common practice known as drafting borrowing. That is, a provision of the law may be borrowed by a draftsman. That is why a regime like NRM can violate inalienable human rights, even if Article 20 prohibits what they do, because it is not rooted in their philosophical beliefs. In other words, Article 20 does not in any way spring from the behavior or the conscience of the members of NRM. People and organizations with a philosophy, NRM in particular, I regard it as a political prostitute. All human rights, Article 20 declares, an inherent constituent or integral part of each human being. NRM philosophy does not say that. Therefore, this article did not evolve out of the NRM political philosophy. As we saw yesterday, the debate in the CA did not in any way reflect what Article 20 provides. Human rights under the 1995 Constitution cannot be divorced from the existence of a human being. That's what Article 20 says, that you cannot separate a human being from their human rights. The two are part and one and the same. In other words, human beings are not like cows or any other domestic animals which man is free to breed, torture, slaughter, or eat, or treat as he pleases. The movement, this statement, of course, the statement I just made may be objected to by the movement for animal rights. The believers in animal rights would certainly object to my statement. But I am giving it as an illustration to make my point about Article 20. Hence, human beings are in a different category of all other animals on the planet Earth, and especially in Uganda under the 1995 Constitution. That is the distinction Article 20 is intended to express, convey, or articulate. It does so in the clearest form possible. Human beings should not be deliberately mistreated. They should not be deprived of freedom without a court order. They are free to enjoy all the rights stipulated in the Bill of Rights, unless an explicit exception is made in the Bill of Rights. Such an exception is subject to court interpretation, if denied of its enjoyment, is illegal by anybody who wants to enjoy that right. In the case of Article 20, the only possible issue that may be raised about its scope and the applicability is the issue of when life begins in order to qualify for protection of inherent human rights. This issue does not, however, arise in the general application of Article 20 to human rights enjoyable by virtue of Article 20. We are here talking about mature human beings who are eligible to vote under the provisions of the Constitution. In short, Article 20 means that since the state does not breed or manufacture human beings for its desired and arbitrary purposes, it is incapable under the Constitution of granting human rights to individual human beings who are presumed to be born with their inherent human rights. The only legitimate function and duty of the state is to protect and enforce the enjoyment of human rights stipulated in the Constitution, not to violate them by whatever methods devised. Article 29, in contrast to Article 20, is a legal rule that enumerates human rights that are inherent and therefore protected under the Constitution. Among these rights are the rights of individuals to associate as they please, to assemble whenever they like to do so, or express themselves in whatever legitimate manner or form they choose, such as articulating on any subject opinions, comments, criticisms, or creating art, music, drama, or any other form of entertainment that enhances and gives meaning, expression, or purpose to their humanity and culture. Whatever it may be, that is the essence of enjoying an inherent human right. The exceptions to the enjoyment of human rights are clearly spelled out in Article 43 of the Constitution. And it says that the enjoyment of the rights and freedoms prescribed in this chapter of the Bill of Rights, no person shall prejudice the fundamental or other human rights and freedoms of others or the public interest. Second, the second exception, the public interest under this article shall not permit political persecution, is not permitted, detention without trial is not permitted, or any limitation of the enjoyment of the rights and freedoms prescribed by this Bill of Rights beyond what is acceptable and demonstrable, justifiable in a free and democratic society. And that's very important stipulation. Acceptable and demonstrably justifiable in a free and democratic society. That phrase is very important because the enactment of the Public Order Management Act seems to violate that very provision, because the minimum standard is what is acceptable in a free and democratic society. And I mention this because it is important, because our journey in protecting human rights has just started in Uganda. But there are other, that's why we rely on comparative studies to understand what has happened elsewhere in order to fill in the gaps in our new recent history of the protection of human rights, say in Uganda. So there are two systems I think we can look at to know what the definition of what is acceptable in a free democratic system is, what the standards are. U.S., for example, limits or restricts the enjoyment of human rights in time and in the manner and place where the enjoyment takes place. Everybody has a right, but the state can determine the time when you can enjoy that right.
We have a call.
Okay.
Caller, go on.
Yes, Council Mubilu, like I call it in the Ugandan way. I just want to thank you for the way you're educating Ugandans, and this is John Mama. And we will need some knowledge put in our system of governance, which unfortunately is lacking. That most advocates that we have that are supposed to be neutral to practice and implement the law have just used it and manipulated it to make a living. Now, one question that I have for you is, as UDU and as a team that is fighting for equal rights and implementation of the laws to help the Constitution be upheld in our country, what have we, because I, as an individual, my advice or my word has always been that we lack civic education. And when you talk about civic education, most people don't understand what civic education is, because civic education involves so many things that goes with it. And the major part of civic education is what you're talking about right now, which is the Constitution. I would say 90% of Ugandans do not know what the Constitution is and what it stipulates. And this will go straight, I'm not lying if I'm lying for this, is even our own parliament that implements and draws these constitutions most of them don't know what the Constitution says. Because I'm saying this, I've tried it and I've asked many that I know that I sit in the parliament about some articles and clauses in the Constitution, and they don't even know anything about it, which is so unfortunate. So as you do, what steps have you taken to help make sure that even my grandmother who still lives right now down, who doesn't know anything about the Constitution, get at least to understand some key areas of the articles and the clauses on the Constitution to help them know that this government is just using them other than supporting them. That is the most disturbing question that I always have. We talk about trying to liberate our country, but until this area is tackled, we are fighting a losing battle. Because if we are not going to help our people understand what governs them, then we might as well say we are not doing any work. So what has UDU put down as a group that is helping to streamline that area? That is my question to you as counsel and as somebody that knows more about the laws that govern a nation or governs an institution.
Okay. Well, thank you very much, John, for that good question. It is important. We have to understand all the implications of your question. Civic education can be carried out freely, for example, here in the United States, and you can reach a certain audience, like you and others, say, who are in the United States or Europe or other countries where, for example, this radio, people can tune in and listen. That we can certainly carry out that kind of civic education which we are involved in right now. However, that's why we are talking about a satellite radio. We cannot reach the population where your grandmother is. And until we do that, our civic education will be inadequate because it will be limited to only the people who can have access either to the internet or to other forms of media where we operate. But I understand that is very important. Second, this civic education is not going to end with the Museveni out of power. When we are in Uganda, part of the way to educate people about human rights is to let the schools. When I was growing up in my secondary school, we used to hold debates, and we used to compete. And at one time, I remember we were very proud. We went to Gaia's, and we thought we are going to win. And the girls beat us anyway. But we learned a lot. And these debates covered a lot of, a wide spectrum of subjects. And if you are doing civic education in Uganda, you would allow the people freedom, say in secondary schools, higher schools, to debate these issues, to confront each other, to hold different opinions. That's the only way you educate people to become democratic by, through civic education. But we cannot do that, as I said, that we are limited because our access to the population we want to educate is limited so far. However, that is the ultimate goal, to make sure that not only people debate in parliament, but people also debate in the secondary schools or even in primary schools. And also, there is nothing better to educate than practice. For example, during Amin's time, they prohibited even electing student leaders. And even the name president could not be used, that you couldn't be a president of a debating society. So that you can see what the problem was right there. But if we liberate Uganda and we open up the process of education, that is of even secondary school children, to debate freely, they will learn that people have rights, and in fact, they should be educated about the Constitution, what it says, and what rights it gives them. That's what I was trying to explain at the Article 20, for example. Do people understand what Article 20 really means? That human rights are inherent, they are not granted by the state. Obviously, the policies of NRM are contrary to and always violate the rights of the people, and the Article 20 itself, and the Article 29, which elaborates in details what these rights are. Those are the ones which you make sure that the people, not just the old people, but including the children, to understand and begin to practice debate and to oppose, to understand that criticism is not abuse, the same thing as abusing, that freedom is important. So thank you for the question, John, and I hope by sooner or later we will have a satellite radio which can be beamed right to your grandmother's house so that she can listen to us and she can understand what we are talking about, instead of our audience being limited to those who are in Western countries. Thank you. So I think right now I'll take a very short break, and I'll be back and continue the conversation. Thank you very much.
You are listening to Voice of Uganda Radio, the mouthpiece of all Ugandans, wherever they may be, to voice their problems without fear of any retribution. The Voice of Uganda Radio works in sync with FADU, the Federalist Alliance of Democracy and Development in Uganda. FADU is an organization that was formed to work as a platform for all Ugandans at home and outside, to work synergistically to liberate our mother Uganda from the ruthless invaders that have sucked it dry. Therefore, FADU invites all able Ugandans to act now and save the Ugandan humanity that is being slaughtered, destroyed, and robbed by a few people unworthy to call themselves Ugandans. Many people are crying for action in Uganda as they languish in misery. FADU echoes their cries by making the loudest alarm to everyone to join FADU, not tomorrow or the next day, but today. The number to join is 408-904-7038. The email is info@fadu.org.
Ekolaganira wamu n'ekibiina ekya Federalist Alliance of Democracy and Development in Uganda, FADU. Ebigendererwa by'ekibiina kino kuzza mirembe, enkolagana ey'awamu, obwenkanya, okuggyawo enkola y'omwana waani, n'okusosola mu mawanga, okutulugunya, okulya enguzi, ebikudde ejjembe mu Uganda. Era kirwanirira okuzza enfuga eya demokrasiya mu Uganda. Ekibiina kino kye kisookedde ddala okukubiriza buli muntu yenna okukyegattako awatali kusosola mu mawanga n'enzikiriza oba ekitundu omuntu kyalimu mu nsi yonna. Kino kye kiseera twegatte tusobole okuzza obupya ensi yaffe Uganda edobonkanyizibwa. Buli eyandyagadde okwegatta ku kibiina kya FADU kuba ennamba eno: 1-8-4-4-7-3-8 oba weeyambise email info@fadu.org.
Fellow citizens, we call upon you to practice resistance and protest against Museveni. We call upon you to oppose strongly the Museveni government, which is responsible for the downfall of Uganda. It is important to know that Museveni is afraid of the millions of people who are living for that day, for the light of day when Uganda will be liberated from his dictatorial regime. Fellow citizens, it's been 24 years of dictatorship. We should all know that at present our drive for freedom has already grown so strong that Museveni has already begun to change his tactics. We call upon people to participate, to organize silent stand-ins for a free Uganda. We call upon people to demonstrate that we're tired of him. We call upon governments in the United States of America and abroad, people in responsible positions, politicians, only to act in the service of peace, justice, and freedom for Uganda. We call upon people to use all legal and imaginative means and methods in order to ensure peace, justice, and freedom for Uganda. We call upon...
After a short break, now I'm back to continue the conversation. And I think before John Lema called, I was trying to let you understand in a comparative perspective what other systems which have been on this journey of protecting human rights much longer than we have, because we are not going to reinvent the wheel, because as some people have already pointed out, human nature is the same. And if human nature is a constant, it is the same all over, then the institutions, to some extent, are also going to reflect the requirements of dealing with human nature. So I was saying that under our Constitution, there is a provision which provides for the exception to the application of the protection of human rights. And those exceptions say there is a proviso which says that you cannot do what is not acceptable in a free and democratic society. And when you apply that test, I think definitely Public Order Management Act fails. But let me go to US first, as I was doing, that the only exceptions, the police has, the state or the police, whatever you want to call it, they can restrict the time, say, of a demonstration, that you cannot demonstrate at midnight. They can regulate the manner in which you demonstrate, that if you are going to use loudspeakers, that they are not going to be too loud to disturb the neighborhood. And the place, they can decide that the best place for your demonstration is not at the in the center of town or where the traffic is too heavy, but in a certain specific area reserved for those demonstrations. These are restrictions which are acceptable in a free and democratic society. So, but when I look at the Public Order Management Act, it is restricting rights and not the time and not the manner of demonstration or the place where you demonstrate. It's restricting your right that the police can decide that you will not hold a public rally, which in fact violates Kivumbi's ruling in the Constitutional Court, which nullified Section 32 of the Police Act. The Police Act was trying to give the police the power to determine whether or not you can hold a demonstration, and that was nullified. And I think the Public Order Management Act may suffer the same fate. But anyway, I'm raising this because of the provision in our Constitution that what you do if you are going to make any restriction on the enjoyment of human rights, that restriction must conform to what is acceptable in a free and democratic system. And that's where Britain comes in too. Britain, most of the rights are under the common law. Actually, in Britain, it used to be the case that a mere probability that there will be violence when people are allowed to demonstrate, a mere probability that there will be violence is not sufficient to say to tell people that they will not hold the rally or the demonstration or whatever they want to do. So you can see that the law is quite broad, and we want to make sure that the restrictions in Uganda conform to these international standards set in a free and democratic society. Those who enacted the Public Order Management Act, they used some form of deception. They said, oh, Britain also has a Public Order Act. Yes, I know that. But the Public Order Act does not restrict people. It may require, if you want to hold a procession for 12 or more people, you may request permission from the police. But you can still go ahead even if there is no definitive prescription in the law that you cannot hold that procession unless you get the permission of the police. And so there is some kind of misleading here. And the Public Order Act of United Kingdom, its primary purpose was to abolish the common law of riot and the common law of unlawful assembly was abolished by that act. And the requirement for a written notice is not actually mandatory, and under Section 11 of that Public Order Act in the UK. So let us not be misled by dictators in Uganda who misunderstand the national standards which are set out very clearly, which are required to be observed, and what is acceptable in a free and democratic society. So I'm saying this because it is very, very, very important for us to always remember that the minimum standard is what is acceptable in a free and democratic society. In fact, I should also mention another incident in New York City where a radical Muslim wanted to hold a rally, and the police in New York City denied him a permit to hold the rally. The reason they gave was that because of his fiery rhetoric, it may cause a riot, or people will fight, or some violence may erupt. but he appealed the decision, and the Supreme Court of New York, they ruled that he had the right to hold his rally, and you cannot deny him by a mere speculation that there may be, because of his fiery rhetoric, there may be violence. So speculation is not sufficient. You cannot just say, oh, we think that there will be violence, therefore we deny you a permit. That is not acceptable in a free and democratic society. I think that point of the exceptions is taken care of. So we do not need to review all these exceptions in order to understand the full scope of Article 29. What is important is to determine how Article 269 impacted or adversely affected the enjoyment of the human rights protected under Article 29, which was an amplification of Article 20 that guarantees all rights are inherent in humanity. Fortunately, Article 29 is explicit and clear enough for anyone to understand its purpose. The purpose of Article 29 is to dispel any doubt by enumerating all the inherent human rights protected by the Constitution and the Bill of Rights. So, Article 269, before it was repealed in 2005, was very different, but clear in its purpose. It purported to restrict the inherent rights to assemble or associate. Its purpose and intention actually were explicit and prohibitive, and they explicitly contradicted Article 20. So Article 269 restricted the inherent human rights so long as the movement system was in force. So that means that was a violation. If Article 20 says human rights are not granted by the state, then the same state cannot enact a law, or even in a constitution for that matter, that takes away those rights. So political parties, for example, under 269, were prohibited to hold annual meetings, conferences. They could not hold political rallies, and their individual members were not allowed to campaign for election as candidates of specific political parties. The provisions of Article 269 prohibited individuals and groups to enjoy their rights to assemble and associate. These provisions of Article 269 directly conflicted with, and in fact also contradicted, the meaning and scope of Article 29. Such a conflict and or contradiction with Article 29 was at war with Article 20, which made it clear that the affected rights were inherent, not granted by the state. The fact that they are inherent and not granted by the state means that the state could not have legitimately used the Article 269 to take those inherent rights away. One provision of the Constitution cannot declare the validity of a specific human right, which another article of the same Constitution not included in the Bill of Rights. Remember, this Article 269 was not part of the Bill of Rights, so it could not wipe out completely or invalidate the provisions of that other article within the Bill of Rights. That amounts to a contradiction. That is, Article 269 was a contradiction. A law with contradictions cannot be applicable either logically or by applying the natural meaning of the words used in the provisions of the law. So Article 29 and 269 contradicted each other, and as a result, wiped each other's natural meanings out, leaving the citizen of Uganda standing there without his inherent rights guaranteed in Article 20. So the people were totally deprived of their human rights because of the existence of Article 269. Hence the charges, the 3 counts of the charges I brought, I read at the beginning against Museveni, Odochi, the Attorney General, and others at large. The 2 articles, therefore, could not make linguistic sense either. In addition, the Articles 29 and 269 were not paradoxical or an apparent contradiction. Together, they amounted to providing 0 human rights. In other words, what Article 29 provided said you have these rights 1, 2, 3, 4, 5, and then Article 269 said you cannot enjoy those rights as long as the movement is in existence. So it wiped them out. So both articles, therefore, together, they amounted to providing 0 human rights. Therefore, Article 269, not being a part of the Bill of Human Bill of Rights, had no place in the 1995 Constitution. It purported to nullify Article 20, which was the philosophical foundation of the Bill of Rights. Nullification of Article 20 would render the entire Bill of Rights a legal nullity or a smoke screen with neither meaning nor legal substance. In fact, the existence of Article 269 in the original Constitution tended to imply that there was a conspiracy among the constitutional makers to defraud the legislative process. There is no other logical and rational explanation for the existence of Article 269 in the original 1995 Constitution. This is an issue which should be investigated thoroughly in order to protect the integrity of the legislative process. Moreover, the significance of this issue goes to the fact that the movement system arose from a social theory known as sectarianism. The question to answer is whether the sectarian social theory, which apparently has since been abandoned, was in fact a valid scientific social theory. This is an important issue in the political and legal history of Uganda, and the obstruction of the process of democratization which it generated. So let us look at the substance of the theory. I know some of you have already, you've heard me explain this, but I'm going to take a different perspective in explaining this social theory again. So don't be bored by my repetition of this theory. It is very important. The issues raised above in this conversation in interpreting Articles 20, 29, and 269 are not moot simply because Article 269 does not exist anymore. The integrity of the legislative process, especially one involving making a constitution, is very important. On such a process depends the protection or denial of inherent human rights. This means that if the legislative process deliberately or intentionally abused or defrauded those responsible, abused and defrauded, those responsible must face the consequences of their actions under the law and be punished if they are found guilty. Hence, the 3 counts I read out at the beginning, it wasn't just a joke, it was serious business. And I will read them out again later on so that Museveni is warned again. The issue here is analogous to committing murder. There is no statute of limitation on serious crimes such as murder and the violation of human rights. Therefore, the fact that the original 1995 Constitution was amended in 2005 and Article 269 was removed does not render the issue we are discussing moot. This is even more so because the movement system was based on a specific social theory that was widely disseminated by its proponents and discussed by the public, the Constitutional Commission, and the Constituent Assembly. One key component of the democratic process is that all participants are presumed to be honest and straightforward in their dealings with the people and between themselves. Honesty, even though a very slippery commodity in politics and public affairs, is essential to the democratic process to enable it to function properly. We shall further probe the matter, the nature of the movement system by carefully explaining the theory on which it was based. This should enable us to determine the extent of the guilt of those involved. They should be identified and isolated for condemnation if they are found guilty of deliberate misuse of the democratic process in the constitutional making process. Sectarian social theory is the intellectual product of Yoweri Kaguta Museveni. It is a theory supposedly based on recent historic experiences of political violence in Uganda. Since the recent political violence in Uganda after independence, we have already, I think, indicated when we discussed state terrorism earlier on in our conversation that preceded this one. So, but the political violence Museveni is trying to talk about, it occurred between 1962 and 1965. That's the only political violence you can talk about in Uganda, in which political parties were involved by for the sectarian theorists. So it means that these acts of violence were actually committed by a body as president of UPC and his security forces, and not by political parties fighting each other, as the sectarian theory tends to portray the situation. The violence committed by political parties in 1962 was minimal and of little consequence. It involved largely of property damage of members of specific political parties, and it ceased or completely disappeared as soon as the electoral season was over. This kind of violence occasionally occurs during elections. India is a good example of such violence. Another period in which political violence was committed under Idi Amin, 1971-79, involved no political parties. So sectarian theory cannot attribute any political party violence to that period because political parties had been banned, and Amin did not prosecute members of any specific political party. This means that the sectarian theorists are short on credible data to sustain their premises empirically. The historical record does not agree with the sectarian theorists' claims of systematic political violence committed by political parties caused by sectarianism in Uganda. A few incidents of people belonging to a political party attacking another of a different political party is not sufficient empirical data to prove the validity of a theoretical postulate, or more appropriately, speculation like the one made by the sectarian theorists. The civil war and truly sectarian conflicts of 1890s in Uganda involved no political parties. They therefore fall outside the premises of the sectarian theory. Moreover, political parties only existed by the beginning of 1950, when they were allowed to exist by the colonial regime. There was no political party violence under colonial rule. The basic premise of the sectarian theory is that the political behavior of the people in a multi-party system is determined by the existence of specific class structures in society, to wit, the middle class. In the absence of the middle class, the sectarian theorists argue, people belong to political parties on the basis of sectarianism, that is, either by religious affiliation or by ethnic connection. As a result of this political alignment, politics becomes predominantly sectarian in nature, and consequently society is divided along religious and or ethnic lines, which cause political violence. In my previous conversation, I did quote Yoweri Museveni saying that if you are allowed political parties to continue, Party A will, those religion A will belong to Party A, and religion B will belong to Party C, and so on and so on. But that is speculation without any empirical data at all whatsoever. So that in the earlier conversations, we saw that ethnicity as a political factor was gradually diluted by the existence of political parties with the political philosophy. The solution historically has been to allow freedom of association to deal with the problem. The NRM solution of suspending political activities under the movement system aggravated the problem. We can also cite a major historic example from U.S. segregation. From U.S. Segregation prevented racial interaction, and as a result consolidated the support of black people to one political party, the Republican Party, between the end of the Civil War in 1865 and the 1930s. The black people in the U.S. supported the Republican Party because its leader, Abraham Lincoln, author of the definition of democracy as a government of the people, by the people, for the people, freed the slaves, and therefore the Republican Party overwhelmingly got the support of the black people. So segregation, that is, lack of personal freedom, consolidated the black vote in the Republican Party. Support of the Republican Party by the African Americans was not based on political philosophy, but on an emotional connection with Abraham Lincoln, who freed the slaves. In the 1930s, the situation changed dramatically when FDR, Roosevelt, that is, assumed the presidency and introduced programs including Social Security that were very helpful and appealed to black people. The black population alignment with the Republican Party came to an end. Many, if not most, black people joined the Democratic Party not based on emotion, but on the philosophy of the Democratic political party at that time. The black people today, like all others, support the political party whose philosophy is compatible with theirs. So race and ethnicity are of less importance. Similarly, Sectarianism in Uganda or elsewhere is best solved by protecting political freedom. People will inevitably join the party whose philosophy they agree with, regardless of their religion or ethnicity or race. Class structure has nothing to do with it. In order to avoid sectarianism, eventually, according to sectarian social theory, political parties must be banned until a middle class appears in order to avoid sectarianism. The best way to do this, in the case of Uganda, Museveni specifically argued, unfortunately convincingly to many Ugandans, was to introduce the movement system of government, whereby the political party activities are suspended until the right sociological conditions exist. That is, when the middle class is formed and fully developed or functional, to cause the allegiance to parties depend on class. In the interim, all political parties should be included in a broad-based government of the movement system. And broad-based government had three major defects. First, by including all bad characters in broad-based government, broad-based government included some of the worst or most notorious human rights violators in Uganda in previous governments. Second, broad-based government was not guided by any rational political philosophy. Third, it was founded on invalid theoretical premises. As a result, broad-based government was built on an invalid social theory with no foundation in history. So, under the movement system, individuals belonged to the movement automatically, which was, in fact, under the Movement Act of 1997, which was a violation of human rights too, because you cannot force people to belong to any organization. The right to associate is also the same right not to associate. So those two components go together. So the Movement Act, which deemed all Ugandans members of the movement, was a violation of human, under the Universal Declaration of Human Rights anyway. It is specific. You cannot force people to belong to associations. So corruption, the composition for political office had to be based on the individual merit under the movement system. Government under the movement system was supposedly broad-based. That is, it included people from all political parties affiliated with the movement system. According to sectarian social theory, the movement system from that theory produced politics, predicted certain things in politics, and appeared to be, at the beginning, it appeared to be a smooth one, but it was not in the end. Obviously, riddled with the violation of human rights, since rights to assemble and associate were suspended under the movement. The idea of a broad-based government was, in retrospect, clearly a political trick. It sounded inclusive and even appeared to be based on voluntary membership. But in fact, this was not the case. The leader of the movement system determined everything from the bottom to the top. At the national level, the leader of the movement system had absolute discretion to choose the cabinet from the public and the members of the legislature. There were no checks and balances built into the movement system. This led to the inevitable fusion of the legislative and executive powers under the movement system, which was later on incorporated into 1995 Constitution, in which cabinet members are also automatically members of the legislature, and vice versa. At the lower levels, the movement had a highly centralized administrative or political structure, beginning at the village level, going all the way to Parliament or the NRC, National Resistance Council. All members of the village constituted the council that made up RC1. The movement system at the village level, that is, the village council, elected 9 members to form the village executive. All the village executives in the parish, Muruka, constituted RC2 council. The RC2 council, in turn, elected 9 executive members who represented them at the next level or the tier of the Gomborora, that is, all the parish executives within the Gomborora constituted RC3 council. All the Gomborora or sub-county executives within the sub-county elected 9 members of the executive to form the RC5 council at the district level, and the RC5 council elected the members of the NRC for the National Resistance Council, which was the national parliament. Under this system, only the village council was elected directly. All the other councils were indirectly elected and therefore not directly responsible to the people as a whole. They were also vulnerable to influence from above. The higher one went in the system, the smaller was the number of the electorate. To that extent, the movement system was not democratic, and it was easily subjected, to control from the top, because the highly centralized structure. The RC system was not a government of the people, by the people, for the people, as the first 10 point, the first point of the 10 points tried to convince us. The complex and centralized structure of the Resistance Council was not a political accident. The leaders in all councils were required to attend a political education course at Chiankwan's political school. The course consisted of a series of lectures on the history of Uganda and how colonialism was responsible for the causation of the political problems the movement system was trying to resolve, such as such as national unity and lack of democracy. In addition to the lectures, the movement system leaders were given a practical course in the use of arms or self-defense. But I understand they used the wooden and not firing weapons. So it was another trick. The mystification of the so-called gun was not really, it did not demystify anything. The movement system was more the ordinary democratic parties. It was also a political indoctrination platform. So the movement system, it was not the ordinary type of political organization. It was a platform for indoctrinating people how they should think, how they should behave. And in a free democratic society, you don't do that. Deliberate political indoctrination is offensive to a free and democratic process where learning is voluntary and not instilled into the people by the state. Such indoctrination destroys the autonomy of civil society on which democracy depends. It is also important to note that the offices held by the executives at each level were identical, reflecting a desire for structured political symmetry and uniformity to be used for the control of the people. For example, there was a title for each executive officer in the RC system: Secretary for Youth, Secretary for Women, Secretary for Security, and so on and so on. This system was uniform throughout the country. These were the so-called leaders who attended the political school for education at Kyankwanzi. The central government, through the local government ministry, directly controlled the entire structure of the councils from the village to RC5, using the NRM executives at each level. Councils had to submit minutes of their meetings to the Ministry of Local Government for perusal, approval, or other political scrutiny, such as security, with a system that clearly resembled a police state system. The purpose must have been to ensure political control from the top. Such a structure was incompatible with a freely created democratic structure, which by its very nature has a built-in principle of democratization, that is, self-governance at each level of the democratic political structure. So clearly the movement system not only resembled the one-party system in the communist countries, but in fact was a species of that type of political system, repressive political systems. For example, the executives above the village level, being indirectly elected, were very similar to at home in Tanzania, Chama cha Mapinduzi, was organized in a similar way. So party structure, so these are not accidents. I'm trying to say, from the theory, sectarian theory, to the structure was not mere accident. In fact, this is where Museveni, in Tanzania, this is where Museveni learned his political skills while attending Dar es Salaam University. Museveni also admired the leadership qualities of his mentor, the repressive socialist Mwalimu Julius Kambarage Nyerere. For over 10 years, there was no meeting of the movement system leadership, either to discuss policy openly or to choose the top leadership. This was, a good symptom about the what was going on. Because it showed there was a political disease ailing Uganda, called the movement system. All the symptoms of dictatorship were there in plain view, but few people paid attention to them. And today that people are beginning to wake up, I think we better understand our history and learn from it. All directives and leadership decisions at the top of the movement system emanated from the president's office. This is not to say that the movement did not have a central leadership. The leadership existed, but it was moribund, because all the major decisions between 1986 and 1995 within the movement were made by either the president or the NRC on a few occasions. What all this reveals is that the movement was a one-man show who is very, very, very well known for being a micromanager fanatic. Nothing was surprising about the way the Museveni, the movement system worked, and the way it was run by Museveni. In view of all this, to call the movement system democratic is to abuse or misuse the word democracy. To describe the period of movement system in Uganda between 1986 and 2005 as democratizing or even a transition to democracy is to misrepresent and misread the history of Uganda. Remember that freedom of association and assembly was banned by the government policy between 1986 and 1995. That is before the Constitution was enacted. It was still a movement system. The same rules applied, and then after 1995, it was the Article 269 of 1995 Constitution was used to control the people and to deprive them of their inherent human rights guaranteed in Article 20. Article 269 was designed to continue the same policy which had been enforced since 1986. During that period, there was no democracy in Uganda if we agree that political freedom is an essential component of democracy. Now we see the clear link between sectarian social theory and the movement system laid out clearly. Constitutionalizing the movement system did not democratize it. Suppressing political freedom under Article 269 of the 1995 original Constitution was done according to a political plan conceived from a theory, sectarian theory. During that period, Ugandans lived under the political repression of one-party political system disguised as the movement system. The fraudulent nature of the movement system is further revealed by the fact that its chief architects were actively involved in amending the Constitution in 2005 in order to abolish the movement system and re-establish a multi-party system. Apparently, the movement system had accomplished its political mission, and it was time for it to fall apart into political oblivion. The question, however, is if sectarian social theory that justified the institutionalization of the movement system was valid, why was the Constitution amended within a decade in order to allow the multi-party system to function again? First, the class structure of the Ugandan society, which was used to justify the suitability of the movement system to Uganda's conditions in 1986, was still was still there in 2005. No middle class had been formed in Uganda between 1986 and 2005. The same peasants were still toiling in the rural villages of Uganda, where 90% of the population still lives. Between 1986 and 2005, the income per capita of Uganda had changed by only $100. This change, however, did not obviously trickle down to the peasants. It was the result of a few foreign investments projects in the capital that affected less than 2% of the population of the country. Therefore, the sectarian social theory was a political fraud intended to grab political power and accomplish nothing more. In his speech on very recently, the State of the Nation speech on June 6, 2013, Museveni made a promise to the people of Uganda that it reveals both the bankruptcy of the movement system, now NRMO, the party, and the invalidity of the sectarian theory. Museveni promised to make Uganda a first world economy by his vision of 2040. This wild prediction transforming the economy of Uganda in the next 27 years. By the way, he has been in power also for 27. Into the first world economy, it shows two things. First, Museveni, for political reasons, makes promises he knows he cannot fulfill. So it tells us a lot about his character. Anybody who trusts Museveni, I pity those who work for him. They still think they can, work with this guy. That is the same thing as saying that Museveni is a liar. Second, these wild promises by Museveni demonstrate that his sectarian theory was concocted to mislead the people of Uganda. The theory had no valid premises behind it. And so now the picture is very clear, and we cannot mince words as some people would want to put it. The problem we face is very big, and so we have to be prepared to fight along. I hate to use seven terms. Protracted war. I hope ours will be a very short war to kick Museveni out. Under the law, what is not prohibited is permissible. So these types, this means that if the law does not tell you that something is legal, you can do it. So these types are the association not to contravene international law as it is expressed in the International Covenant and Civil and Political Rights, and these two international instruments, the Universal Declaration of Human Rights. They are on our side, and I want to emphasize this point, that when you are teaching international law, there is what they call the sources of international law. The sources of international law, they can be treaties, or they can be eminent scholars. Now, one of these eminent scholars, Thomas Frank, he published an article in the American Journal of International Law in 1992. And in that, the article was entitled "The Emerging Right to Democratic Governance." So this emerging right, he derives it from Article 21 of the Universal Declaration of Human Rights. The Universal Declaration of Human Rights now, as you know, is a source of international law. It is called the customary law. That's another source of international law. And the universal right, what it provides, that Article 25 of the Universal Declaration of Human Rights says every citizen shall have the right and the opportunity without any of the distinctions mentioned in the article, and without unreasonable restrictions. One, to take part in the conduct of public affairs, directly or through freely chosen representatives, to vote and to be elected at genuine periodic elections, and third, to have access on general terms of equality to public service of his country. That's the Universal Declaration of Human Rights, Article 25, and then we have another provision, Article 21, which provides that everyone has a right to take a part in the government of his country, directly or through freely chosen representatives. Now, these two provisions in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, they give rise to what Thomas Frank called an emerging right to democracy. So, when the movement system existed in Uganda, it was a violation of this right. Ugandans have a right to democracy, but the movement system was designed to frustrate and prohibit the people from enjoying their human right. And this is, as I said, sources of international law can be in eminent international law scholars like M. Frank, and customary law and the treaties. Now, let me quote Frank. He wrote that the entitlement to democracy in international law has gone through both a normative and customary evolution. It has evolved both as a system of rules and in the practice of states and organizations. This evolution has occurred in three phases. First came the normative entitlement to self-determination. Then came the normative entitlement to free expression as a human right. Now we see the emergence of a normative entitlement to a participatory electoral process. So clearly what Thomas Frank was saying was that there is a universal human right that has arisen under international law, which grants all human beings a right to democracy. And what the movement leaders did was to violate this right. And therefore, hence, I started off by these count the charges against Museveni, Odochi, and the Attorney General for violating our human rights. The mere existence, that's what I'm trying to point out, the mere existence of the movement system was in itself a violation of our human rights, because it deprived the Ugandans of their right to democracy. So we must fight it, and we must correct this, and hopefully this will be much sooner than we may believe, or we may think or anticipate. So I think this is a good point to stop for a few minutes, then I'll come back and give you my conclusion. Thank you very much.
Eno ekolaganira wamu n'ekibiina ekya Federalist Alliance of Democracy and Development in Uganda, FADU. Ebigendererwa by'ekibiina kino kuzza mirembe, enkolagana ey'awamu, obwenkanya, okuggyawo enkola y'omwana waani, n'okusosola mu mawanga, okutulugunya, okulya enguzi, ebikudde ejjembe mu Uganda. Era kirwanirira okuzza enfuga eya demokurasiya mu Uganda. Ekibiina kino kye kisookedde ddala okukubiriza buli muntu yenna okukyegattako awatali kusosola mu mawanga n'enzikiriza oba ekitundu omuntu kyalimu mu nsi yonna. Kino kye kiseera twegatte tusobole okuzza obupya ensi yaffe Uganda edobonkanyizibwa. Buli eyandyagadde okwegatta ku kibiina kya FADU kuba ennamba eno 1-8-4-4-7-3 oba weeyambise email info@fadu.org.
You are listening to Voice of Uganda Radio, the mouthpiece of all Ugandans, wherever they may be, to voice their problems without fear of any retribution. The Voice of Uganda Radio works in sync with FADU, the Federalist Alliance of Democracy and Development in Uganda. FADU is an organization that was formed to work as a platform for all Ugandans at home and outside, to work synergistically to liberate our mother Uganda from the ruthless invaders that have sucked it dry. Therefore, FADU invites all able Ugandans to act now and save the Ugandan humanity that is being slaughtered, destroyed, and robbed by a few people unworthy to call themselves Ugandans. Many people are crying for action in Uganda as they languish in misery. FADU echoes their cries by making the loudest alarm to everyone to join FADU, not tomorrow or the next day, but today. The number to join is 408-904-7038. The email is info@fadu.org.
Eno ekolaganira wamu n'ekibiina ekya Federalist Alliance of Democracy and Development in Uganda, FADU. Ebigendererwa by'ekibiina kino kuzza mirembe, enkolagana ey'awamu, obwenkanya, okuggyawo enkola y'omwana waani, n'okusosola mu mawanga, okutulugunya, okulya enguzi, ebikudde ejjembe mu Uganda. Era kirwanirira okuzza enfuga eya demokurasiya mu Uganda. Ekibiina kino kye kisookedde ddala okukubiriza buli muntu yenna okukyegattako awatali kusosola mu mawanga n'enzikiriza oba ekitundu omuntu kyalimu mu nsi yonna. Kino kye kiseera twegatte tusobole okuzza obupya 4-8-9-4-7
I'm back to conclude this today's conversation, and I've been talking about the right to democracy. Hello, I'm back to conclude today's conversation on democratization of Africa, the case of Uganda in a comparative perspective. I stopped at discussing the right to democracy, and that's very, very important, because if a right to democracy exists under international law, then it means that people have a right to enforce that right, and they're entitled to use all means possible to achieve that right. I must point out a few things here at this point. And first, Uganda signed the International Covenant on Civil and Political Rights. He ratified it in June 21st, 1995. So, from that time on, Uganda was bound under international law to comply with the provisions of the International Covenant on Civil and Political Rights, which I have just cited, which gives rights to a right to democracy. It is quite curious. Uganda signed. It was the last one to sign this covenant in our area, in our region. For example, Tanzania, which was a socialist country, system, they signed the same covenant in 1976. Rwanda signed it in 75. Kenya signed it even earlier, 1972, and Burundi in 1990, also earlier than Uganda. So you see, we have a problem. We are the problem, and recently there has been a movement, for example, to enact the Money Laundering Act. Again, but Kenya passed this act, 2009, Tanzania, Macharia, and I think in 2006, and Uganda has just tried to enact this law. And this law is the one that is used to monitor the money laundering machines and the corruption that goes on. So the fact that Uganda is slow in enacting these laws and enforcing them is an indication that the regime in Uganda is not ready and willing to comply with the laws. So, but let me complete the conversation with another aspect of democratization. That is the role of civil society. And the evidence is clear from what I've said that NRM does not believe or did not believe in democracy because of the way it treated civil society. We conclude, we make this conclusion because by looking at an important aspect in the process of democratization, namely the separation of civil society from the state. You cannot just achieve democracy or democratization before the elements of civil society become fully autonomous from the state. And when we look at the history of the government in Uganda, the opposite emerges. We do this from two perspectives. First, we look at NRM policies in order to determine to what extent they were, consistent or designed to promote democratization by fusing civil society with the state. Second, we look at the universal picture for comparative lessons from history. What does separation of civil society from the state entail? To what extent is culture now or before in the past, was it a factor in this process? What are the implications of these questions on social change in general, and how does social change constitute a part of democratization? There is both historical and contemporary evidence showing that there is a definite link between separation of state from civil society and democratization. The more autonomous state and civil society become, the greater or further democratization advances. Separation of state from society is therefore an important and necessary step in the process of democratization of emerging political systems. The state consists of the population and the three branches of government, and together with their instrumentalities. Instrumentalities means the armed forces, the police, intelligence agencies, and the civil service. Society consists of individuals and groups independently created in society. These groups include organizations such as political parties, civil organizations, trade unions, professional groups, and so on and so on. These groups and their individual members are protected by the Bill of Rights. The rights we talked about, the inherent rights of which each individual is born with. These rights, they invigorate the democratic process by exercising the right to assemble, to associate, and express themselves. So democratization requires that the civil society groups and the different elements of the state be separate, detached, and autonomous from civil society. This is why in a previous conversation, we characterized military coup d'etats as obstacles to democratization because they violate the fundamental rule of democracy of separating the state from civil society. Military rule represents the least democratic political system possible. It is not surprising, therefore, that NRM, which is a military regime in disguise, has been so oppressive and undemocratic. In fact, NRM has representation of the army in the civilian legislative body of parliament. What is important to point out about the separation of civil society from the state is that an autonomous civil society by its nature, as long as freedom of association, assembly, and expression are protected, tends to be diverse. That is because the different groups in it consists of have different interests to protect, and therefore represent a different voice in the democratic process. That's why it is very important to protect political freedom, because there can be no democracy without political freedom and an autonomous civil society. When the state tries to either to control or to dominate civil society, conflicts of interest between the society and the state inevitably develop. This is usually the trigger of the state to try to suppress political freedom before the state loses control. When civil society is autonomous from the state, it is clear from the available scanty evidence that political systems with advanced civil society organizations, such as South Africa, democratize much more faster than those without advanced civil society organizations, such as Uganda. Why is this so? The answer lies in the nature of the democratic process itself. For a democratic system to exist, the people in civil society must have the ability to challenge the government, that is the state, its present and future policies. This can only be accomplished effectively by diverse autonomous groups in civil society which operate independently of the state to look out for their interests. The adversarial nature of democracy requires it, and for democracy to thrive, it is a necessity. A close look at NRM policies since 1986 shows that instead of allowing civil society to thrive independently of the state, NRM was doing the opposite. NRM policies were originally designed to fuse the state and the society. Moreover, this was the time when the leaders of the movement system, were actively advocating the sectarian social theory, which in fact turned out to contradict the prediction of the theory NRM leaders were preaching. The original strategy of NRM in 1986 was inconsistent with the creation of an independent middle class, which was autonomous and independent of the state of Uganda. Anyone who genuinely believed that a middle class that was autonomous from the state was essential for democratization, a gospel Museveni preached intensively, would have made sure that the state and civil society were allowed to be independent of each other by, for example, promoting the protection of political freedom, which generates autonomous civil society groups. Instead, the leaders of the movement system embarked on an intensive program to achieve the opposite, that is, ruthless suppression of civil society and fusing the movement system with the state by making both of them one and the same thing. Political strategy contradicted the assumptions of the sectarian, the social theory they advocated, namely that the existence of an autonomous middle class is the foundation of democracy. The truth is that dictatorship in any form, regardless of what their leaders say, always focus on controlling civil society in one form or another in order to prevent civil society organizations either from existing at all or strengthening and acting autonomously from the state. Under communism, which provides the best historic example in this case, the organizations that would be active in civil society were incorporated into the state structure through the Communist Party in the form of women, youth, or workers' wings of the Communist Party. Their absorption into the state politically neutralized them. The policy was designed to destroy their autonomy in civil society, such as policy was clearly anti-democratization. NRM tried to replicate the Chinese and Tanzanian models in Uganda, thereby delaying the separation of civil society from the state. Before we examine the environment in which NRM operated, let us glimpse at what happened during the 1990s under Idi Amin, because dictatorship is a dictatorship, whether it is of Amin or Museveni. In Uganda during the 1970s under Idi Amin, any form of social organization was seen as a threat and therefore was automatically banned under the law, thereby making it impossible for civil society to exist independently of the state. Ironically, in the case of Amin, his main political achievement was the transfer of Asian businesses into the hands of Africans. But the representation, the repression under Amin was so much that no independent business organizations were formed in civil society to exist automatically from the state. Most of the so-called mafuta mingis, the rich businessmen, for the duration of Amin's regime, 71 to 79, were hardly distinguishable from the state for two reasons. The manner in which they acquired the businesses by the simple allocation from the state did not assure their autonomy from the regime in power. The existence of mafuta mingis was not based on the ability to run business, but on personal connections with the military officials within Amin's regime. Second, the so-called mafuta mingis were not real business people. They ran most of the businesses into the ground, and by the time Amin's regime collapsed in 1979, most of the so-called businesses had gone under. A few of them and the economy were in tatters. Moreover, the period of 9 years undergoing political tumult and uncertainty was not conducive to long-term planning and business success or investment through politically sensitive investments such as business need security to thrive and grow. The absence of an active civil society is comparable to the sociological death of democracy. The creation of pathological fear of the state, as we saw earlier in earlier conversations, was part of the solution for Amin. Instead of incorporating civil society into the state, Amin terrorized it so much that it was not necessary to politically neutralize it. So unorganized people, the dictators like Amin believed, posed no threat to the security of the state they tenaciously controlled. So you see here the connection. If people are unorganized, civil society, cannot be effective, and therefore you can control them. The sociological reality is, however, that the state derives far more security from its legitimacy in a civil society than from either pathological fear caused by its security agencies or the network of civil society appendages to the state, like the movement system NRM created. This history explains why Uganda has a light civil society compared to her neighbors like Kenya. This historical this history enables us to understand the environment in which NRM operated. When we look at NRM history, a new activity pattern on controlling civil society emerges. In 1986, when NRM came to power, it invented the word, or copied, and established a socialist system from some other places like Tanzania. This had two direct political effects. First, the move drastically weakened the civil society, that is, the existence of the movement system, as it made it subservient to the state. It made the civil society subservient to the state. This is important evidence to prove that NRM leaders either did not believe in democracy or did, but did not understand what the word democracy means. I don't know which one is true of those two. I would tend to think that they knew, but they are just ruthless and power-hungry people. These are the two directives. Now the second reason NRM expected everyone to conform to the official policy of directives from above. Dissent disappeared, and the movement system, like any hegemonic socialist communist party structure anywhere, was automatically and deliberately fused with the state. there was one supreme command post located in the president's office to run the movement system. See the similarity between Amin and the Museveni? It's amazing that we can even talk about the similarities, but it's amazing that it is true. This was an anti-democratic move meant to control civil society and not to democratize it. In effect, as we have shown in earlier conversations, the political structure of the movement system was meant to obliterate civil society by merging it into the state and effectively silencing it. Diversity, which is the main characteristic of and source of strength for civil society, was squeezed out of the Ugandan society. The movement and the state became one and the same political entity. As a result, three things happened. The movement system was eligible for funding by the state. The second, the movement system formed part of the security system of the state through the local defense force, which was part of the RC system structure I described earlier. And lastly, the movement system was absorbed into the civil service of the state through the local, the RC structure, which was part of the local government system. So the armed forces were politicized. These components were the most disguised the fusion of the state and the movement system. The ultimate evidence of the total constitutional fusion between the state and the movement was officially recorded in the 1995 Constitution. The fact that the 1995 Constitution provided for the movement system within the national constitution means that the national constitution recognized a specific political organization with membership from civil society as a part of the state. Technically, civil society ceased to be a critique of the state, which is its main function in a democratic system, since it was part of the state itself in the form of the movement. The official recognition of the movement in the Constitution was not only anti-democratic in nature, but a political organization in a democratic system should not be officially recognized as an institution of the state. For example, here in the United States or in Britain, political parties like the Democratic Party, they cannot be part of the U.S. Constitution, or the Labour Party in Britain cannot be part of the Constitution of the British, although unwritten. It cannot be incorporated. That would be wrong. But this is what we got from 1995 Constitution. People were clapping. I was disgusted. People were saying democracy. You couldn't. Democracy couldn't have been farther from the truth there. So it becomes an organization, once it is part of it is constitutionalized, like the movement was. It becomes unequal to all the other political organizations which are not officially recognized in the Constitution. In fact, such a move violates the principle of separation of powers. The movement system was only part of the government. It was not only part of the government, the legislature and the executive, it was also part of society in a different capacities and designations. Two questions have to be answered. First, how did this happen? Second, why did it happen? The incorporation of the movement system, or NRM, into the state structure was the result of careful political calculations when the NRM supposedly won the war. NRM at that time had to figure out how to act to eat its cake, that's a military victory, and keep it too through the movement system. Unlike the democratizing processes in South Africa, for example, between 90 and 95, which was long and torturous, NRM had no rivals strong enough to challenge its authority and hold it accountable by preventing it from incorporating itself within the state. There were two types of political groups at the time, 1986, NRM, when he claimed victory. The first group consisted of the groups which fought the war with the NRM, either both as allies or rivals. These included UNLA, FUNA, FEDM, UFM, and so on and so on. Those who also want to be more information, read the book by Kutesa. You will find a lot of information there. The second group consisted of political parties which did not directly participate in the war but had support within society. It was these two groups which the leaders of NRM conspired to opt into the movement system to form the so-called broad-based government. This process was accomplished by NRM, which by NRM swallowing up its political rivals by pretending that they are part and parcel of the broad-based government. And I have to admire the naivety of our politicians at that time, because they thought there was good faith in whatever was being done, although it was quite transparent. One could see what was going on. Both groups, that is the political parties and the military, those are the fighting groups, were politically weak, but NRM feared the political parties most because of their potential political strength if they were allowed to be organized. The fighting groups were exhausted, literally exhausted from the war, and their memberships were fast dwindling due to both a ravenous disease called HIV/AIDS and corruption. Many of them were voluntarily crossing over to join NRM in a similar way Luvaramira has just done recently. These they desperate. They wanted to be accommodated. These fighting groups wanted to be accommodated as a means of political survival. So, unlike the military groups which had no political constituency, the political parties presented a different threat to NRM. They were potentially powerful if they were allowed political freedom to organize themselves, as we pointed out above. So now you know why Article 269 was put into the Constitution, although it was illegal. But it was designed to weaken the political parties and to prevent them from challenging the NRM. So the point here is both the political parties and the fighting groups, they had very little bargaining power at that time in 1986, because not only were the political parties were painted by NRM as collaborators and opportunists who worked with the enemy during the war when it suited them, but it was in their interest after the war to join the winners of the war in order to guarantee their political survival. The leaders of NRM exploited these weaknesses to their maximum, and they finally invited both groups, the political group and the fighting groups, to join the movement system. The rest of the world, looking at that scene from outside, unfortunately, saw the whole process as goodwill and magnanimity in victory on part of NRM. Nothing, however, further from the truth. NRM was in fact politically weak at the time and did not have much confidence in itself. It fluked the war, as they say, and for some who have reliable information. Otherwise, it would not have been desperately devising the means to control the process by cajoling its future partners into putting them into a political trap. However, few, if any, political analysts really understood what was going on. The political weakness, short-sightedness, and greed for power of both groups, as manifested by their behavior during the Civil War, made them succumb to the temptation to join the movement system. Their political fate was thereby sealed. They became part of the movement system, even though in reality they remained and were deliberately kept at the periphery of NRM and the movement system as a whole. The rest is, of course, history. The two groups, unfortunately, by succumbing to the temptation to join NRM, contributed to the disappearance or weakening of civil society. And that's my point. and the process, and complicated the process for democratizing Uganda. Our history would be different if the political parties refused to be part of the NRM system. That's my conclusion. Anyway, I could be wrong. Sometimes I wish I was wrong when I'm right. And the answer to the question why is that the NRM leaders were not genuine believers in democracy, as we have outlined, as history has amply illustrated. So that's no longer a mystery of any kind. And when we read, for example, their contribution to the CA debate, which I did yesterday, went over yesterday, those who listened, there is nothing striking or impressive coming from what a visionary democratic leader would say. If the NRM leaders had been believers in democracy, the CA general debate was the place to express their philosophy on government, to display their commitment to democracy by articulating a vision of an eternal flame of the democratic leadership they had lighted in 1986 for posterity. Instead, within the CA, all the flames were flickering. Article 269 extinguished the flickering flames. What the NRM leaders really wanted most at that time, in 1986, was a political system that controlled as an end in itself, and not a means to guide the nation to democratization. So now you see, the history is very easy to understand if you study the facts carefully. The sole purpose of creating the movement system was summarized in the word tuarire. Corruption was ingrained in the system from the beginning. A visionary could have predicted anything but democracy from NRM. The three books which were written by for example, by the NRM leaders, there's one by Kutesa, another one by Kategaya, and one by Museveni. When you read them, there is nothing philosophical there about democracy. It's all about power, power, power. We did this. I mean, it was this. We did that to so and so and so on. They are not telling you that if you want peace, justice, and democracy, this is the way to go. This is the formula. I've tried to read these books, and I found nothing of the kind. This analysis gives us a new perspective, hopefully, with a historical background to the problems inherent in democratization under NRM. Democratization, as we pointed out elsewhere, was impossible under NRM before the multi-party system was restored. It is particularly difficult to appreciate that point because the importance of separation of the state and civil society in democratization process was ignored or even misunderstood. So you cannot democratize a political system without creating an autonomous civil society. And the NRM has been all along fighting to prevent that. That's why they control, the police does not want people to demonstrate. They don't want people to have freedom, to associate, to assemble, to express themselves. The enforcement, the brutal, rigorous enforcement of the law sedition before it was declared the unconstitutional contains all the evidence that these are not people who are democratic, that they don't have a political philosophy compatible with the democracy, and therefore you have a long, rough road ahead. And yet, under Article 269, freedom of assembly and association were explicitly denied to political parties and individuals who desired to protest the NRM policies, as long as the movement system was in force. So long as the movement system was part of the state, democratization was not just difficult but impossible. The mousetrap was carefully placed in the Constitution itself. There was no solution until the Constitution was amended in 2005. And then what is even more disturbing is the corruption which inevitably resulted from the fusion of the state and the movement system. We identified corruption as an obstacle to democratization. Now it is clear why. Since the movement was founded on the state, by the state, there was no separation between the party or the movement funds and the state funds. The movement secretariat was in fact a department in the president's office. One sadly recalls the 5 million shillings offered to each of the 300 or so MPs in order to support the amendment of the Constitution in 2005 in order to remove term limits. It can't get worse than that. Maybe it can. First, one wonders why a normal MP, genuinely interested in democratization of his country, and I think MPs, either they are blind, or if they are not, they should know that without democracy there cannot be security, there cannot be peace, there cannot be the country cannot develop. Now, why should an MP need a monetary incentive in order to perform his civic and legal responsibility to vote for the restoration of political freedom by reinstating a multi-party system to which the people are entitled as a matter of human right, because people are there is a right to democracy, and also under Article 20 of the Constitution and 29 of the Constitution. That is an example of corruption gone, what the amok, I think that's the word they use. Civil society did not protest such a flagrant abuse of power. And you know why? Because civil society is weak, is controlled, There is no political freedom, but even more important, civil society is ignorant about their rights, as John Lema was trying to raise the point. Second, even after the multi-party systems was restored, the NRMO continued to be funded directly by the state. Its activities organized at Chankwanzi, for example, where we've seen them enjoying the roasted meat, all that is funded by the state. They are treated as if they were state functions, and they were directly funded by the state. Allegations of institutionalized corruption in Uganda are not mere allegations. Many commissions of inquiry have documented the corruption, and the Auditor General's annual report to Parliament reveal incredible corruption, which the regime does not seem to bother about. The NRM regime in Uganda is so corrupt that it cannot reform itself. Only regime change can uproot the institutionalized corruption in Uganda. Much of this corruption is attributable to the fusion of civil society with the state. Let us look at the process of separating society from state from a historical perspective. Separation of state from civil society is one of the most important stages in democratization of the political system. Democracy is also the most effective way to fight corruption by mobilizing civil society to attack corruption in government. And you know why they harass people who do that. One of the reasons why fighting corruption in Uganda is a hopeless task is because civil society has not political teeth to bite the MPs in Parliament. If MPs were worried about being thrown out of their lucrative offices by their constituencies, they would behave differently. They would disassociate themselves from the NRM regime, which would mean making them accountable to the electorate. Right now, it is not a political liability to be an NRM MP. So that's where one of the problems is. That is why separation between state and civil society are very important. For now, however, our main focus is on the historical process of how separation of civil society advanced the democratization process. There is no chicken and egg conundrum when it comes to deciding which came first, democracy or the separation of state from the civil society. This is an important issue because it can be used to test the validity of the theoretical postulates modern social science has taken for granted and operated on for over a century. We need to answer one of the crucial questions. Was culture involved as a causal factor in the separation of state from society? Is Western culture an inherent part of democracy? We shall use England again as our experimental ground. The Magna Carta of 1215 looms large in this historical story. It has been very little to do with this historical story of the Magna Carta. Explains how English society became autonomous from the state. So we believe this conclusion puts Weber's causal connection between Western culture and democracy in theoretical jeopardy. Over time, the application of Weber's culture theory has undergone various interpretations. One of these, which is usually very common and popular and Eurocentric at the same time, is the education of the culture theory to the equation of the culture theory to democratization, and it also to talk about Western values, which supposedly are responsible for maturing of democracy in the West. The theory has been reduced to a simple proposition, namely that democracy thrives where specific Western cultural values exist. These cultural values in this context may vary from one author to another, but they are easy to recognize by the general conspiracies or whatever, the labels given to them. They are conspicuous. I didn't watch the time carefully, and I have already gone over the 11 minutes, and the new program, I think Gwanga Mujje has to start. So I will stop here, and I will continue next time on this issue to see where culture, whether culture or Western culture in particular, was part of democratization process and what implications that has.